All right, welcome everyone. Jeff Segal here for another web presentation from Medical Justice. I am both a physician and an attorney. I practiced as a board certified neurosurgeon for approximately a decade and then became an attorney. And most of what we do is defend doctors against all sort of medical legal challenges. We started off with frivolous medical malpractice litigation, where we defended and helped defend doctors. We've expanded to internet-based assaults on reputation and filled in gaps managing hospital credentialing issues, medical board complaints, national practitioner data bank reports, employer-employee conflicts. The list goes on and on. Every time I think I've seen it all, I am proven wrong. All right, so what are we going to talk about today? Today, we're going to talk about HIPAA. And by the way, the first thing you need to know is HIPAA is spelled HIPAA, not HIPPA. And not infrequently, I get a letter from an attorney saying that, somehow the doctor violated HIPAA with two P's, which tells me that they don't really know a whole lot about that actual law because it is spelled HIPAA. So what I want to do is go through some of the nuances of HIPAA just to educate you to see if you may be violating it. There are a lot of details on HIPAA. It's a very, very large law, and there are things that we think we know that are incorrect and the other way around. So let's dive in. So HIPAA was a law that was put into place a number of years ago, and it has been amended or updated a number of times. And some of the rules, even if the statute is the same, the rules get updated through Health and Human Services. And of course, it has to evolve because the technology evolves, patient expectations evolve, and enforcement priorities evolve. And even if you're doing everything right at one point in time, you can drift out of compliance over time. And while HIPAA 20 years ago wasn't really enforced, at least if it was enforced with a wrist slap. But now you get HIPAA wrong, it can be associated with really horrific consequences, including large civil fines, and you get placed on the Hall of Shame, which is a website that Health and Human Services puts out. All right, so one of the issues that's out there is the pixel tracking issue. And you're probably going, what is a pixel tracking issue and how does that relate to HIPAA? So pixels are tracking pieces of data that the large entities such as Google, Meta, Facebook place in there so that they can track who's been to a particular website and what they're actually looking at. And Health and Human Services initially believed that this could expose protected health information, even if they didn't capture any names or date of birth or any other traditional protected health information. But if somebody with a known IP address, for example, is searching for information about management of HIV, you can start connecting the dots. You can certainly see why the argument was made, how Facebook, for example, would know because they know quite a bit about the individual who's searching. Now they might understand their searching tendencies and connect some dots and believe that, well, this individual has HIV, even if they don't. I mean, it would just be a probabilistic calculation. Nonetheless, HHS, who oversees HIPAA, HHS is Health and Human Services, OCR is the Office of Civil Rights in HHS. In any event, they said this was forbidden, and they told the universe that if you've got a healthcare website, you really need to block any type of tracking pixels put on there or that you would put on there doing the bidding for Meta or Google. In any event, this went to litigation, and the courts ruled in favor of the American Hospital Association, meaning that Health and Human Services, OCR, lost, meaning that there just wasn't enough to conclude that this was a breach of HIPAA, that that there was a exposure of protected health information from people searching with the tracking pixel in place. And this is very technical, but I think it's one of those reversals that was actually good news for the doctors and I guess bad news for Health and Human Services because they had tried to police what Google and Facebook were able to track going to a healthcare website, such as a hospital's website, such as a doctor's website, and they lost. And OCR, Office of Civil Rights for Health and Human Services, opted not to appeal. So at least as part of the federal landscape, the the playing field was frozen. That HHS's position on tracking pixels was that for the most part, they do not breach HIPAA. There's no disclosure of protected health information. So you think, okay, that's great news. I don't need to think about this any longer. I'll just make sure I'm happy to have 1,000 tracking pixels on my website so I can get all of this information and be able to market to the end of the universe. But we live in a country with more than federal law. We live in a country with state law, and state privacy laws still apply. And I will also tell you, state lawsuits still apply. So even though Health and Human Services, from an administrative standpoint, stood down and said that HIPAA doesn't apply to tracking pixels, it turns out that state privacy laws were used to execute and win a number of lawsuits or settlements. In fact, there have been several, what I would call eye-popping lawsuits related to these pixels on a state level. These were these were lawsuits that were filed in civil court, and at least one settlement was 18.5 million bucks. So that's a pretty big number. It was a large entity. So I guess I'd argue it was proportionate to the size of the institution, but that's a pretty sizable amount of cash, $18.5 million. So what's my point here? My point is that if you have tracking pixels placed onto your website by Meta and Google, you are at risk for a lawsuit, and it's usually a class action lawsuit, which would be addressing state privacy laws and disclosure of protected health information. So if it were me, what would I do with tracking pixels on a website which could connect the dots for Facebook or Google? I'd probably block it or ask that it be removed or make sure that it's taken down. All right, so I beat myself to the punch here. Make sure you know what's on your site. If you outsource your website to a marketing team, ask the question, are there tracking pixels on my site? Yes, I'm sure that I know you know that HIPAA has is not going to beat me up because of that, but I don't want to get sued in state court with a class action lawsuit because I'm not even sure whether insurance covers that or not, and I don't want to dig deep into my pocket and have to pay a sizable fine or settlement actually. So you want to remove or restrict tracking in any page, which arguably even touches protected health information. Honestly, if it's just your contact information, that's fine. But if you've got a site where people can go into the weeds and a third party could connect the dots and, you know, believe that the searcher, the person searching, um, has that particular health condition, it makes their case a lot easier. But if the information is benign and there's not much on there, arguably, there's not anything to do. Anyway, if you are working with any third party tracking information, just make sure that they also honor the privacy and make sure you've got a business associate agreement in place with that entity. Anytime you touch protected health information, if you're working with a vendor, they need to have supplied you or they need to have signed a business associate agreement. And this coordinates with legal, information technology, marketing, because that's the place you're going to get burned. Marketing is where people take or cut corners, take chances. So just be aware of this issue that's out there. It's not a HIPAA problem per se, but it's a privacy issue that manifests itself in state court. All right, next big bucket, which didn't exist when HIPAA was drafted as a law and implemented as a law, would be artificial intelligence and chatbots. So chatbots may collect and transmit protected health information. I can well imagine you have removed a human from this process, and now you have a chatbot which is gathering information about an existing patient. It could just be your virtual answering service, and they are just collecting information of your existing patient's problem so they can transmit it to whoever needs to know about it. The problem is that the off-the-shelf solutions for chatbots, they're not HIPAA compliant because as we alluded to earlier, you must have a business associate agreement in place if there's any protected health information. It could be that technically they are secure, meaning that the information is transmitted securely and that it's secured securely, both important components of being HIPAA compliant. But the final cherry on top of the sundae is that you need to have the vendor sign a business associate agreement. So, as an example, if you have a paid account with Google, um, paid account, meaning that it's a business account, you write them a check, they will give you a business associate agreement. So, if you are storing information in its cloud, with a business account, not the individual account that's free, but the business account where you're paying money, you likely have a business associate agreement, and that's okay. But if you are using Apple's cloud, the iCloud, for example, it's technically secure, meaning that information is transmitted securely to iCloud. It's stored securely in iCloud. But what's different? Well, iCloud does not give you a business associate agreement. So can you store protected health information in iCloud? No, you can't. You can't if you want to be HIPAA compliant. Now, it doesn't mean it's not secure. It is secure. It's transmitted securely, stored securely, but there's no HIPAA business associate agreement. I know that sounds like a technical issue, but by and large, if HIPAA comes calling, and there's a complaint, they're going to be looking for your HIPAA business associate agreement. So in any event, going back to the artificial intelligent chatbots, they're often put into place by vendors, and any vendor that touches protected health information must be technically secure information getting transmitted and stored securely, but in addition, need to have a business associate agreement signed and in place in your file cabinet. All right. Yes, just make sure that if you have a vendor for your chatbot, you have asked the question, are you HIPAA compliant? And they'll often say yes. But the inquiry does not end there. You're going to say, okay, then please send me your HIPAA business associate agreement so I can sign. If they're going, what's that? That's pretty telling. To me, that would say move on to the next vendor to vet because that vendor has no idea what you're even talking about. But if they say, hey, look, we'll be happy to send our business associate agreement to you, that's a pretty good sign that they've taken this seriously and they know what they're doing. Um, be careful about the types of responses related to non-protected health information. You want to limit it to non-protected health information. So these tools should mostly be focused in the non-protected health information space. The more you touch and feel protected health information, the more safeguards you'll need in place. Log interactions, make sure that to the extent you get rid of this information and flush it, you should follow a particular policy and protocol. Can you get rid of information? You can. It's almost like emails. If you've got a retention policy, the answer is yes. But if it's something that goes into the medical record, you will necessarily be beholden to your state's medical record retention laws. And every state is different. Some states mandate you keep medical records from the last visit for at least 5 years, others 7 years. You'll have to check and see what your state allows. But if it's not anything that would ever go into the medical record, then probably want to have a policy that gets it flushed at some point in time. Disclaimers, make sure there's a disclaimer. Tell people to limit the amount of information they put in there. You want to educate on the front end so you don't have to take care of things on the back end. But at the end of the day, you don't want an artificial intelligence engine making clinical decisions without any human oversight. I think as good as AI is becoming, there's still a human component. And remember, AI is not going to be sued. You will be sued. And just be careful about the oversight. There needs to be a human implementing clinical judgment. All right, so let's go into photos and how they appear on review sites and social media and your website and so on and so forth. So here in this particular example, they've blocked out the eyes, so you can't in theory, tell who this is. Right? Wrong. The game has changed. I mean, it would be a very simple matter to de-identify this individual. And even if you don't show the entire face, it is possible with context to de-identify an individual. So if you're putting photos online, remember, humans can be identified by other means, such as tattoos, the scars on their body, the background of where the picture is taken, potentially the timestamp, and unique clothing. I've seen cases where somebody is arguing that's my underwear, my unique underwear. Nobody else would know that, but that patient knew it. So they're trying to say somehow their privacy has been violated. Um, just be careful before you put everything up. Make sure that you clear it with the patient with a HIPAA authorized consent form or HIPAA authorization so that you have their permission. And be cautious about having a global authorization on the way in the door. And the more sensitive and intimate the photos, the less enforceable that will be, meaning you won't be able to rely on it. So I've seen surgeons, cosmetic surgeons, aesthetic surgeons who have a global authorization when the patient hasn't even been seen yet by the doctor. It says that you provide um, permission, authorization to post before and after pictures of your surgery on the internet. And what if they're before and after breast augmentation procedure? Um, has the patient knowingly given their authorization? Arguably not, because every patient's getting it. They haven't even met the doctor yet. They haven't even decided on surgery yet. I think it's hard to give authorization when you don't even know if you're going to have the surgery. So I would say that to the extent you're going to place photos such as this online, you should do it after they've had the procedure, once you kind of know what the relationship looks like, and they've given you a knowing authorization based on their outcome and based on your relationship with them. If a patient wants you to take down a photo, do it. Why? Because HIPAA mandates it. HIPAA basically says that the patient can revoke its HIPAA authorization at any time as long as they can get it to you timely, but once you receive it, the clock is ticking and you have to take it down. Now, there are some situations where you cannot take it down. So, for example, if you used their authorization to post a photo in a medical journal, it was published and then mailed out, you can't unwind that. I mean, that's out the door, and a good HIPAA authorization will say that sometimes when protected health information has been disclosed, it can't be undisclosed. But in this narrow situation where you do control a website, arguably your own website, if they ask you to take down the photos, just do it. And make sure that you have standardized your workflow for placing photos online. I would tell you to make sure to have two people always sign off on something because some practices do rush this and assume that they had the authorization to post online, and then lo and behold, they find in this unique situation with the patient complaining that nobody got the authorization. A thought B would get it, B thought A would get it, but at the end of the day, it is not in the medical record. So I think it's not a bad idea if you're going to post sensitive photos online to market your practice that you have two people sign off on it. Could be you, the physician, and one other individual. Just make sure that there's a fail-safe Mechanism, we have two people who hold the keys to launch a nuclear war. Certainly for something even more significant, like placing sensitive photos online, you would definitely want to have two people managing. By the way, that was a joke. Posting photos online is not more sensitive or more challenging than starting a nuclear war. All right, responding to online reviews. Um, if you reply and you release any protected health information, you're acknowledging that this individual is your patient, and you cannot disclose that someone was your patient unless there's a HIPAA exception. And there is no HIPAA exception for correcting the record. If somebody is posting something online about what a horrible surgeon you were and what you did and how you caused an infection and you overcharged them and so on and so forth, you are not allowed through HIPAA to correct the record. Your argument would be, well, hey, the patient outed themselves, so how can I out someone if they've already outed themselves? That's a very good logical argument, but it doesn't jive with HIPAA. HIPAA really makes no exception for correcting the record. And more importantly, I think above and beyond HIPAA, if you sound defensive, you could end up looking like a fool. So there's a professional way to make this work. And if the patient files a complaint to Health and Human Services, Office of Civil Rights with Health and Human Services, you could have taken a minor problem and turned it into a much bigger problem. So here's a very safe HIPAA reply. It's boring, and I would tell you not to put up a boring and impersonal response. So I've seen this. We take feedback seriously and strive for a positive patient experience because privacy laws limit what we can say publicly. We can't discuss care here. If you're comfortable, contact our office so we can listen and help. Then we'll see 5 of these, below, which makes it even sound more impersonal, like you're a number, because we can't even be bothered to write something unique for each response, each negative response that's out there. So I would tell you to resist the urge to put something cookie cutter like this. It is true and it's accurate. I mean, it does basically telegraph what the law actually is. And you'd like to respond, you can't respond because of privacy laws. But I think there's probably a better way to manage this. Let me back up. So, what do I mean by that? What do I mean by a better way to manage it? So, you can't disclose protected health information, but you can send a educational signal to the public. So, for example, if in the example the patient says that Segal is a butcher, he operated on my face and ended up getting an infection, and he wanted to charge me 15 grand to correct his mistake. Okay, so I wouldn't say anything about this case, but what I could write is that we wish 100% of our patients had a optimal outcome with our practice, but not everyone has the perfect experience. On occasion, our patients will get an infection. Our infection rate is, let's say, 1%, which is 2% below the national average. Nonetheless, for any individual who does get an infection or a complication, it's 100% to them, and we will stand by them and try and correct any problems. We will not abandon our patients. And by the way, to the extent we have to do a revision procedure, we will often waive our professional fee within a reasonable time frame. So what have I accomplished by doing that? Well, the first thing is I haven't bored everyone to death with this very dull, we take feedback seriously response. Next, I have not disclosed any protected health information. I have said absolutely nothing about this individual patient that wrote the review. I didn't say why they got an infection. I didn't say they were non-compliant with the treatment plan and went back to swimming in a swamp 3 days post-op. I don't say any of that. I'm just basically trying to tell everyone what our policy is, which is sometimes people will get a complication. Our complication rate that this patient is alleging is below the national average. So everybody gets this complication. We get it less frequently than our peers. And finally, it's preposterous that they're saying I charged a ridiculous sum of money to fix a problem when our general policy is to waive our professional fee to do a revision procedure. I didn't say we did it in this patient's case, but if that is our policy, we're sending a signal to the public. This is how we manage complications. So that's a much better way to manage this. It's not boring. It won't put you into general anesthesia. And it describes to the public a marketing message, not definitely on point with what the patient was complaining of, but it hits on the general topics which do need a global response. All right, so in terms of the things that are new that are out there, we used to have a handle on where data leaks. We used to understand what a breach of HIPAA meant, but now we're seeing it in places we never expected before, such as tracking pixels such as artificial intelligent chatbots and replies on the internet. And even when you've done a great job in following HIPAA, which is a federal law, there are still state privacy laws which can compound the risk and turn into settlements, judgments that HIPAA never really implemented. HIPAA is not a private right of action. The best the patient can do is complain to the federal government. The federal government then opens up a case, and they may beat you up and they may fine you, but that's not a private right of action. The patient will not get money related to filing a HIPAA complaint. They can get money if they file a lawsuit in state court arguing a breach of state privacy laws. So in any event, compliance is what we think it is. It's something that's not one and done. Rules change, laws change, technology changes. Every so often, you need to dust the cobwebs off and rethink, am I at risk and how do I prevent from becoming Exhibit A, either in a lawsuit or an administrative complaint from a federal agency? All right, you don't need to do everything at once. I think if we did everything at once, it would be onerous and burdensome. So you can do this over time, but some of the things that we talked about was to just take a look at the website and just make sure that that you've audited for these tracking pixels. You can do that with your marketing team, whoever manages your website. To the extent that you have an AI chatbot, just make sure that you're working with a reputable vendor, that you have a business associate agreement in place. Um, if you've got photos on the internet anywhere, every photo that goes up needs to have a signed authorization. And if somebody says, take down my photo, the one thing you don't want to do is say, hey, look, you signed an authorization. I can post it no matter what you say. It's too late. That's not the law. The law says that a patient can withdraw or revoke their HIPAA authorization. And once they do, to the extent you can take it down, you must take it down. If you're going to put something online as a response to review, you got to make sure that it's HIPAA compliant or doesn't disclose any protected health information. And I'm not even sure what this last thing here is with incident response and data request processes tested. So how did that get there? I have no idea. All right, so you just have to stay up to date. Often it helps to have an attorney or HIPAA compliance expert keep you up to date, but this is never going to be one and done. And while it sounds daunting, you don't need to do everything at once. And if you don't know how to do this on your own, just ask others to help you do it. Others have been there, done it. We certainly help our client to manage this process. All right, if you have any questions about this thorny topic, feel free to email us at info@medicaljustice.com. Again, that's info@medicaljustice.com. And thank you for your attention. Just a little bit about who we are and what we do. We've been at this now for now 24 years, helping doctors address a collection of thorny medical legal challenges, including frivolous lawsuits, disputes with challenging patients, online reputational assaults, board complaints, hospital credentialing issues, employer-employee problems, so on and so forth. So if you want to learn more about who we are and what we do, feel free to click on the QR code or just go to medicaljustice.com medicaljustice.com/schedule, medicaljustice.com/schedule, and you get a free 15 to 20-minute consultation looking at your thorny medical legal challenge. All right, that's a wrap. Thank you for your attention.